All right, well, welcome. My name is Mary Jetton, and I'm here to talk about don't risk it all, which means don't risk everything as you're building your business. So, just a little bit about me. I'm a lawyer, I'm an accountant, I'm an ASU grad from law school, but I'm originally Canadian, so you'll hear some strange pronunciations of things as we go along. I started my career as a financial auditor and an accountant, and then I ended up in law school here in Arizona in about 2008. And so when I graduated, 2010, I can't believe it's almost 10 years ago, I decided not to become a lawyer, and instead I had seen errors that small businesses had made, entrepreneurs, inventors, when I was in law school during something which used to be called the Technology Ventures Clinic. And so there I saw that these very well-meaning and smart entrepreneurs were making some basic business mistakes that came back to bite them. So I'll talk about a few of those as I go through the slide. But what I've done is, since then, is I started a company called TrackLight, which is up there, and you can go there. There's a free business risk assessment that you can take, and it truly is free. You don't have to pay anything. There's no credit card required. So it's a free business risk assessment. I created TrackLight as a response to the challenges that I saw small businesses having. So it's a platform where there is a paying aspect to it. We have partnerships with big companies like Paychex. And so the idea is, though, if anybody wants to use it for free, they can go and do that part on business risk. And so tonight we're going to talk about business risk, but we're also going to talk a little bit about intellectual property, which is one of the places where people fall down a lot. I'm also a practicing lawyer now. I'm licensed in Washington State, which is where I live now, and so I practice business law for larger companies who don't want to hire an in-house counsel, so they have outside in-house counsel, or outhouse counsel if you really want to make a play on words. So tonight we're going to talk about kind of 10 top things. It's organized in 4 different sections, or maybe 5, I can't exactly remember. And so we're going to go through the slides, but if you have any questions as we go through, please just raise your hand and let me know. Okay, cool. So when you wake up in the morning and you go to get yourself organized for the day, does your day look anything like this? Sort of your brain, all the different things that you have to do. So all of us face this just overwhelming list of tasks. And the idea is that these are the 5, so it was 5. These are the 5 basic areas that we're going to look at. Most of us start businesses with a couple of goals in mind. You might want to provide for yourself. You might want to grow a business and sell it so that you can make a lot of money. That's the dream, the unicorn dream, sort of like unicorns, very rare. And then there's the basic idea that actually millions of Americans are doing, which is you start a business so you can sell it and then retire. And there's some statistics that there is some trillions of dollars of value in businesses that Americans are planning on selling to fund their retirement. So it's really important that you don't make any of these mistakes so that you can sell your business to retire. So we're going to talk about these 5 different things: getting legal, getting people, getting your offering or your product out there, not getting sued, because often people think, okay, I'm just going to do all of these things. I'm going to make sure I check all the boxes. I'm going to do everything right that I need to do to protect my business. But then along the way, they accidentally do things that might get them sued by somebody else. And those often are around intellectual property or infringing on somebody else's space. And then finally, we'll make sure that we tie everything up as in terms of being able to sell or retire. Okay, so this is just one of those fun little word pieces. These are all different things that have to do with running a business. So no one gets up in the morning, I don't believe anybody gets up in the morning and says, this is the morning that I'm going to assess my business risk. This is the morning that I'm going to make a list of all the things that I hate doing, all the administrative tasks that I'm going to, just jump on that today. Like, I'm going to look into my insurance. That's a pretty big one here in the middle. Or, today is the day that I'm going to create an employee handbook. You don't think of these things. It's nothing that anybody wants to do. But it's super important because otherwise you can end up with huge problems. So, has anyone seen the show Silicon Valley? It's on HBO. Have you seen that or no? So
I watched it once and it gave me this stress sweats, so I
well, the Silicon Valley company is called Pied Piper, and throughout this little presentation I have some call outs to some of the shows because it makes it more interesting. We actually have a free white paper on Tracklate where it talks about if Richard, who's the CEO on Silicon Valley, if Richard would have had the Tracklate business risk assessment and done it, he wouldn't have gotten into as much trouble as he gets to on the show. Obviously, there wouldn't be a show. It wouldn't be as interesting. It's amazing. The first 2 seasons revolved around the concepts that we're going to talk about tonight, revolved around intellectual property, yet they made it funny and really engaging. So if you want to watch more of it, it's actually quite funny. So the first things that you need to do is you need to absolutely have an entity. And, you're nodding. The statistics are frightening in terms of how many people in the United States do not have a business entity, but are running what are called sole proprietorships. So it's in the millions. I believe it's my memory, which is not always perfect. My memory serves me correctly. It's about 16 million people on their taxes report as a sole proprietor. So does anyone have an idea why that's not a good idea?
Because of the risk.
Because your liability is great.
Exactly. So if you don't get an entity and an EIN, which an EIN is, you need that to open a bank account. And the reason the Pied Piper is right here is that on the show, it's kind of funny. Richard gets a investor to invest in him, but he hasn't set up a business entity. So he goes to the bank and he tries to deposit a check that's made out to Pied Piper. And of course, he doesn't have a business bank account. So the lady teller is basically saying to him, well, you need to have an entity. And you can't open a business bank account without an EIN. And so it's quite amusing because he leans over and he's like, well, could you just take care of that for me? Like not realizing that this is something that you actually have to do. So the EIN is required, and the reason I'm going to say it like 3 different times is people create these entities and then they just say, oh, I'm just going to use my own bank account. Like I'm not going to actually create a business bank account. I'll just create an LLC. It's the same difference. I'm the only member, the only person in the LLC. So I'll just use my own bank account. I don't want to have to pay more bank fees, or I don't want to have to do whatever. So that can actually get you in a huge amount of trouble because
You're commingling.
exactly. So you are on it. So you're commingling, which means all the liability protection that you're trying to get from having a separate entity, just gone. So, and plus any sort of tax issue, you can also have tax issues, which is beyond the scope of what we're going to talk about. So the first thing is don't go it alone, and you need to get an entity, as we just talked about, because of the personal liability. An LLC will only help you if you operate it completely and utterly separate. And if you do some of the things we're going to talk about next around insurance and things like that, you can't just create an entity and then never kind of run it as a business. if you have a substantial amount of revenue and expenses, you should have an accounting system for it. You need to be able to substantiate how you're spending the money and that it's a separate entity. So the difference between a C Corp and an S Corp, are you guys familiar with that? Or okay.
I'm an accountant.
Oh, okay, you're an accountant. Okay, there you go. So I'm like preaching to the choir on this. So as far as getting one of these set up, you can do it yourself. You can hire a lawyer. You can hire an accountant. Yeah, accountants.
CPA.
CPA will set up a business for you. This step was not done by one of my clients at the Tech Venture Clinic. And what happened is he and a group invented something. And after inventing it, they filed for a patent. And so when you file for a patent in the United States, you have to list the inventors. And at that time, they didn't have something that they have now, which I'll talk about in a minute. But at the time, he just had the three of them file because it has to be in a person's name. They filed the patent. They didn't have a business entity. So they had no business entity to assign it to. And because they didn't have a business entity, that meant that when the patent was issued, each person had the right to go and, they use the word exploit, but that's just basically monetize. They had the right to individually go and monetize that technology themselves without talking to anyone else, which meant one of them could have gone and got a worldwide license exclusive, and they would have got all the money from it. That's why there's, at the time, there was a way, all you did is tick a box and assign it to a company. And then the company would own the intellectual property. Now there's like an automatic way of doing that. Before you had to file this other form and tick that box. But the whole bottom line was this person didn't have an entity because they had the foresight to file the intellectual property, but they skipped over these steps. So many people, as you're an accountant, you know that this is important, but so many other people, they think, oh, well, I'll just run it as a sole proprietorship, who cares? Well, of course, as we were just talking about, you're liable. One of my favorite examples is somebody was telling me, there's no need to have people learn about this stuff. Like we're talking about people who are dog walkers or painters. And I remember thinking, okay, those are people like you. If you're a dog walker and you're walking someone else's dog and that dog bites somebody and you have no entity and no insurance, you're risking all your personal assets.
Your house.
Yeah, your house, your car, your savings, your retirement, all of that. And the same thing, a painter. A painter could do property damage right at this moment. I have painters at my house. So they're there, they're painting, they could break something, and I would expect them to pay for it. And so that one is the first one. It's not necessarily the most important one, but it's kind of one of those threshold. You need to have that, otherwise you're not really running a business. So next one, which will be very exciting for you. Books, records, taxes, insurance. Again, nobody wakes up in the morning and goes, woohoo, except for us accountants. I get pretty excited, this time of year when I went in last week and even though I'm an accountant, I don't do my own taxes for the business. And so I went in and I filed my law firm taxes and Tracklight's taxes and I signed them, and it gives me a great feeling to know, okay, I'm compliant, I've done this. But you'd be amazed. I've spoken around the country. I spoke in New York, and it was on a different matter. We were talking about investing, and one of the companies came up. It was these two co-founders, and they said to me, so we got $1 million. We raised $1 million, but we're trying to figure out which accounting system we should use. I was like, what do you mean? What have you been doing with the money? And they're like, well, we got a bank account and we've been spending, but we don't really have an accounting system. And it's like 6 months after the investment. So, I mean, hopefully an outlier, but you need to have discipline and set up books and records and outsource this. If you're an entrepreneur and this is not something that gets you all excited to do, then find somebody. There's so many amazing systems now in terms of, you don't have to use something like QuickBooks, but QuickBooks Online is still pretty good. You've got Xero, FreshBooks. There's a whole bunch of different accounting systems. They're all, there's no more having to have them, have an accountant come in. We, at Tracklight, I have someone do our books, and I have actually never met this woman. She's lovely over email, but we have a whole system set up, and she just does our books. And that's the way it can be. And as an entrepreneur, you need to be on top of this. And insurance needs a special mention. Depending on what you're doing, depending on what your website offers, you might want to look into cyber security type insurance, cyber insurance. It's a big deal with the breaches that we've had. Even if you're a small company, you need to have the proper terms of service on your website and privacy policies and all of that. But ultimately, even if you disclaim everything, people might come after you if there's a data breach. So that's something that you need to look into. Okay, so now we're going to talk about people. And going it alone as an entrepreneur, that whole you're in your garage by yourself, that is a reality. I started Tracklight myself. I started another business called Evolve Law with another person out of New York. So I've started a couple of businesses, and it's never really just only you, because you end up having to have people help you with things. Like, even when I first started Tracklight, I was like, I don't know anything about marketing. What am I going to do? And as Tracklight, we were one of the first, we were in the first cohort at CEI, the incubator over by the airport. And when we got there, I knew that we were going to find more people and get people in. So I found a business attorney who could then help us with some of these things. But this, sort of like the entity, you're going to have co-founders and you're going to have a team. And the idea that you don't have any agreements in place, that you just do a handshake, is a recipe for disaster. I've now been doing sort of this entrepreneurial. Before law school, I was more of a corporate America person, but now I've been doing this entrepreneurial type approach since 2010. I worked for a small company here that was a startup, and I think it's almost like marriages. 1 and 2 of these co-founder arrangements will have some sort of split. Because sometimes there's just not 2 co-founders. Sometimes there's 3. Sometimes there's 4. But I, even, in my with my entrepreneurial hat on, and now with my Nimbus Legal, which is where I work, hat on, as a lawyer, I've already seen, I just started doing the lawyering part of it last year. I've already seen 2 or 3 co-founder issues, split ups, and I've only had probably 6 clients. So it's pretty much a 50% like, there's always going to be problems, and it just is one of those things where there will be the problems and there will be conflict. It's just whether the resolution is laid out properly or not. So the first thing is not to do everything on a handshake. The idea that people start businesses and it's just like, hey, we've been friends forever. Let's just, take it based on faith. It's headache, as the slide says, or it's heartache too. So I've seen co-founders who have no agreement basically end up spending, trying to remember as an example, I'm not going to name names, but these two folks, male and female, they're out of Los Angeles. I think the final lawyers' bills were in the six figures, so hundreds of thousands of dollars. And we're not talking about arguing over a large company here. So a lot of strife, and it's not just the time that it takes or the lawyer, it's the amount of time that it pulls you away from running your business, which is what you got into business to do, not to be in this constant dispute. And that goes not just for the co-founder agreements, but you need to have agreements with your employees or your contractors. So I don't know if anyone watches the show Nashville. Did anybody?
No.
There was a napkin agreement. Just write it on the napkin and a signature, and that was one of the episodes. And so it's, when you start watching TV and start looking for these things, you can actually find them in all kinds of movies and everything. There's something about IP, there's something about a business. I taught a class, technology law, at ASU last year in the W.P. Carey undergrad law, pre-law, or whatever they call the specialty. And I went through and I found all these different really cool movies to get people to watch, like Joy, the one about the founder of McDonald's. They all have intellectual property and these type of issues in them. But napkin agreements, you can try to enforce them, but really it's just not a good idea. It's the best thing is to get professional agreements done. And again, there's lawyers who can do this, but there's so many free agreements now out there that, and just a little caveat, I don't mean to Google, I need an employment agreement, and then just take whatever you find, because you will probably end up with something that's not applicable to Arizona. And there's big differences. Employment law is state by state. So, excuse me, so if you're employing somebody in California, it's very different than in Arizona. California, you're not allowed to restrict people's ability to get a job. There's no such thing as a non-competition or a non-compete, as they call it, in an agreement in California. But you're allowed to have that in Arizona. Now, there are different rules on how broad that can be and how it can apply. And again, it's state by state. But if you look on some of these services where, you're looking at something like a Rocket Lawyer or a Legal Zoom or some of the legal plans, like Legal Shield has a free app that you can download that has free agreements on it. And those are, I believe, state by state. So you can be creative, or you can go find a lawyer who can help you with this. But it's critical. So, sorry about that slide. It's not contractor. That's kind of strange. So, employee versus contractor. I'm sure you're both familiar with this concept that when you hire people, they are classified as either an employee, in which case you have to pay, pay various FICA and Social Security and all of that, and then you have to withhold tax from them, and there's filings and everything, and you have to pay the unemployment and all of that. With contractors or 1099s, you don't have to do that. You can just pay them according to a contract. But do we get to decide? Who decides whether somebody's an employer or a contractor? The company decides, but do they get just free choice, or?
I imagine the tax man.
Yes, ultimately, you can't just decide, I would like to save a whole bunch of money, because an employee will cost you more because you're paying their share of all of these social benefits and everything. You don't get to decide. There's a lot of fines and there's a lot of penalties if you misclassify people. Now, contractors have to be true contractors, and there are a whole series of what's the word I'm looking for? there's a series of kind of criteria, there's the right word, as far as who's a contractor versus who's an employee. And so what startups tend to do is say, I'm just going to hire everyone as a contractor. And you have someone who's working for you and only you, and you're telling them exactly what to do, and you set their hours, and you might be giving them the materials to work. You're giving them a laptop, you're giving them a phone, you're setting them up in an office. If you're doing all that, it's one of those things like if it walks like an employee and talks like an employee, it is an employee. And here in Arizona, like other states, you have is it DES, I think? Department of Economic Security, DES. And so they monitor what's going on with companies here in Arizona, and you can get audited to find out, are you properly classifying your people? And if you're not, you're going to have fines and penalties. And the other one that people often think it's fine for interns, we'll just call them, contractors, and we'll also just, even have unpaid interns. That's not okay. Unpaid interns are not okay. Interns are supposed to be paid if they're doing something that an employee or a contractor would be paid for. So there are labor laws around interns, there are labor laws around employees versus contractors. This is an area where you should not do it yourself. This is not a DIY area. This is an area where you should seek legal advice, because this isn't necessarily an accounting thing. This, and I'm all about the accountants too, since I'm an accountant also, but this is a legal area where you should spend a little bit of money to go talk to a lawyer if you are trying to make people contractors instead of employees. If you're making them employees, if you want everyone to be an employee, then that's the default that all of the IRS and the states like that, because then they're going to get their share of the taxes. So this is an area where a lot of people have been tripped up. Yes?
So real quick, specific industries, I've seen a lot of people who have articulated, hey, there's specific industries, salons come to mind, right? Where they say everybody's a contractor. No, that's just our industry, it's the industry standard. What would be your articulation, especially in industries where increasingly you have to build your own client book, right? You are running your own business. However, you do have to be in a specific space at a specific time, which to me was always like the differentiator between an employee and a contractor. I was just kind of curious your thoughts. What would be your advice for people who say, well, it's always been in the industry? And the flip side of that is I've seen lots of people who are new to industries who are saying, hey, the only way I can get traction is to be a 1099 or to be an independent contractor. What would be some of the languaging or advice you'd give those people and people who are in those type of industries where this is just the standard?
Yeah, and so again, I am a lawyer, but I'm not your lawyer.
Yeah.
The whole disclaimer. So one of the things, like if you look at, let's say, a salon, if you're renting space, in a salon, then that would allow you to say, that's like renting an office space. And I would be an independent contractor because the people that I'm getting my revenue from, it's a whole bunch of people. So if I hire someone to help me in the salon and they're like a 1099 because they're, my assistant, that's where it gets a little wonky, because it's like, okay, my business, I'm the business owner, so I wouldn't necessarily be a 1099, but the person that I hired to help me, let's say, wash hair or do something like that, they would likely be an employee because I would be directing them. It's really, you have, as a 1099, you have to not just have one 40-hour-a-week client, and you need to be able to be providing your own tools. So if I was a hairdresser and, I rented a chair and I had, like, somebody told me, okay, you can have it this many hours, that's not as much the hours directed. The hours directed that they're talking about are like, hey, I'm a web designer for XYZ company, and I'm going to come in, I'm going to be told our hours are 9 to 3, you have to be here from 9 to 3, and here's exactly what you have to do. As opposed to, I'm renting a chair, nobody's telling me what haircuts to do, whether I offer, this type of haircut, that type of haircut. Do I only cater to women? Do I only cater to men? Do I cater, you're choosing all of those things. That makes you more independent, and it's more like a landlord-tenant type arrangement. The industry thing, the challenge with that is that the DES comes out with rulings, and based on their rulings, you kind of have to keep up, because they could make a change. They could be like, hey, all these people used to be freelancers, and now we're saying that, if this freelance writer works for you full-time, then they're really not a freelancer and they should be an employee. But it's one of those things, I think you can phone up DES and ask them anonymously. I have this scenario, I think they would give you some advice on that. But it is definitely something that has been changing, and that various states have been cracking down on the gig economy, because people set themselves up as freelancers, but then they have one client. So it's like, okay, you're really not a 1099, and you should be paying all of these expenses. Okay, so now we've got everything set up, we've got everyone with agreements, we are filing our taxes, we are doing everything, and we're banking correctly. So now we're going to try to grow. So with the growing, we're going to talk about the biggest thing that any company has. I get a lot of feedback like, I don't need to know anything about intellectual property because I don't have any. And it's like, every business has a name. So you're going to end up with some issue with your name. So even if that's your only intellectual property, which I promise you is not the truth, and we'll get into a few of the things that are actual intellectual property that most businesses have, you're also going to deal with people creating things for you. As a small business, you're not going to do everything yourself. You're probably going to have to work with outside people, and that's going to get into ownership issues, which, not to spoil the end of this, but if you want to sell your business, you have to make sure what you're selling at the very end, that you own it. So this is why laying the proper foundation is super important. And then as you grow, there's going to be a lot of innovation, and you have to make sure that you are keeping that innovation to yourself. Not yourself personally, but to your company. When I was growing Tracklight, we had a CTO who signed all of the agreements. So we had independent contractor agreements and we had employees. And the independent contractor agreements, some of them were for people who weren't actually making any money. They were supposed to be compensated by getting a piece of equity. So we had those agreements. And in those agreements, we also had something called a proprietary asset agreement or something, big long name. But basically it was saying anything that you make that we're paying you for, either with equity or with cash, anything and everything gets owned by Tracklight. So it's pretty simple. So, we had people that we paid to write blogs. We had people that we paid to write code. So we owned all of that. But we had this CTO, and the reason I can tell you this story, I'm not going to tell you his name, but the reason I can tell you this story is because he disappeared and stole our development server. It was supposed to be kind of in the cloud, and when we went there was nothing there. He had put it all on his own server. And so he disappeared for about 5 months. And when he resurfaced after many certified letters and all this type of stuff, we of course had let him go because he was in breach of his contract, which in his independent contractor agreement said, you can't steal anything. So we'd let him go, and he wrote and he accused us of stealing his intellectual property, which so much irony. So in the whole thing, given what Tracklight does. So we were like, what are you talking about? and the we was the lawyers, were like, what are you talking about? You signed something that assigned everything over to you. So that went nowhere because we had all of the right agreements. But it's also, even if you have all of the right agreements, terrible things happen. And he was not a co-founder, so it wasn't a co-founder split. It was more of just a bad hire. So, on to more positive things. So, with names, you have to protect your name because you don't want other people using the same name and creating confusion. However, you can't use the R, as you see at the bottom there, unless you actually file a trademark. But you can use the TM. So a TM, you can slap that on. It's called a common law trademark. If you launch a website, you put something out there, and it's your name, your new company name, you can put the TM up. You don't have to file anything to do that. You can just do it. And that shows people that you have the intention to monetize using that name. You can also do it for slogans. You can do it for basically anything that you would file a trademark for. And if you have a service business, you would put SM for service mark as opposed to trademark. And even if you don't put that, if you start using a name in business and you record your date of first use, so for example, with a website, it can be the day you launch it. With a restaurant, it could be the day you open, the day you put up the sign, etc. The idea is that you're putting that line in the sand when it's yours. Because if somebody comes along and tries to file a trademark with the same name in the same industry, then you can actually, even if you haven't filed a trademark, you can go back and say, no. I have common law rights. I used it first. You cannot use this. And this, you might think, oh, this never happens. This happens all the time. And if you're thinking that you are going to use a name, but you don't have it offered for sale yet, you don't have it out there, you can actually file something called an intent to use trademark. And so that intent to use kind of is your placeholder. So there is a restaurant, I don't know if I have this slide in here. Oops. I don't know what I've done. Sorry. No, I don't have a slide in here, but I'll tell the story. There was a restaurant to be here in Phoenix that was going to open, and they spent money on signage, and they spent money on menus, and they developed their name and their branding and everything, but they didn't want to spend the money on an intent to use and then later transfer it over to, you pay, I forget the exact amount, and these numbers would have changed because this is an example from about 6 years ago. You pay a certain amount and you get your intent to use, and then you pay an additional amount to switch it over to being in use. They didn't want to do that. So they kept their name secret, but it wasn't so secret. Somebody must have heard about it. So another restaurant stole the name and opened up first and started selling and offering under that name. Do you think the first restaurant could do anything about it? Nope, because the second restaurant opened first to use, out there, could prove it. When this other restaurant was like, whoa, we better file, it's like, no, you can't file. So I got the story from an attorney friend of mine because this first restaurant said, hey, help us now because this other restaurant wrote, and they had spent all this money already. Well, the first restaurant had to rebrand. And rebranding is very, very expensive, as you can imagine, for a restaurant where you've got physical big sign and all of that. So this is there's a couple of IP misconceptions in here. I've had so many people ask this question of me. Okay, but I have the domain name. So that's the same thing. I can use this. So I like to use the example that if I got the domain name coca-cola.mary, that really wouldn't do me, even if it is available, that wouldn't do me any good. Like Coca-Cola, I can't operate as Coca-Cola. They have all these trademarks. So I've had questions like, what if I put the name, but I change some letters in it? So it's the same pronunciation, but a different name. The whole idea of a trademark is that it gives an exclusive right for one person to use a name to avoid confusing the general public. So forever, if you renew it, you can have your name and only you are using it. So like when I open a Diet Coke anywhere in the world, which outside of the US would be a Coke Light outside of North America, when I open it anywhere, I know I'm getting Coca-Cola. That's a deal. They've paid for the trademark. That protects me as a consumer. I know it's going to be Coke. It's not going to be Pepsi because I hate Pepsi. Sorry, too. I don't know if ASU is a Pepsi campus or a Coca-Cola campus. But we're in the library, so we're good. So that protects a consumer. If you try to set up a business that's going to have a confusing name, the USPTO, the United States Patent and Trademark Office, they're not going to give you a trademark because it will cause confusion. So the idea that you get a domain name that's very similar to another company that operates in the same area or the same type of business, that would cause confusion. Now, there's lots of examples where you have similar names, like Apple, you think of computers. Then if you had like the Apple restaurant, nobody's going to get confused between calling a restaurant Apple and calling the Apple now. If you rolled back a long time ago, that would be a strange, and somebody would have said 30 years ago, you're going to have it's probably longer now, 40 years ago, you're going to have computers called Apple. So the misconception is that just because you get a domain name, that does not give you a trademark. So if you're starting your business, you don't start by getting a domain name. You start by looking to see if there's anyone else doing the same thing as you are in the same industry with a similar name. And it doesn't have to be the exact same name, and it certainly can't be this clever changing of letters or whatever. So this is from Pied Piper. In the show, they did this whole thing that Richard went down because there was Pied Piper Irrigation Company. So it was a little bit disappointing because there would never be confusion between a software company, which is what they're doing on the Silicon Valley. There would never be any confusion between that and an irrigation company. But they were trying to show that he needed to rebrand unless he could get this person to agree to give up his rights. So the rebranding that I have seen, I know very recently, which I can't disclose it, somebody that I know found out that their company, which they'd already done a whole bunch of research and a whole bunch of outreach with investors, they had to change the name because they found somebody else that was super close in the name in the field. So you want to get on that first. Okay. Work for hire. Are you guys familiar with the term work for hire? No?
Nope.
No, okay. I was hoping you would be so I could take a sip of the water.
Sorry.
Okay. So when you hire somebody to do your code or do your website or do your branding, you have to make sure that whatever contract you use, so first we all know now you should be using a contract, and those folks are usually they're depending on your business, they're not necessarily going to be somebody who becomes an employee. You're going to say, hey, I need a new website, can you please design it for me? So the first thing is that you need to read this is a theme that will come out. You either need to read or you need to delegate it to somebody who could be your lawyer. Somebody needs to read all of these agreements, because often when you go to hire somebody to do this type of work, they have a contract. So they will come to you and say, here's my contract for developing your website. You need to read that contract. The most important thing, other than the price, would be what happens to the code, the website itself, the fill in the blank, the work that you've hired. So work for hire is an idea that unless you are specific with the work that you're hiring, with the rights to that, they'll default to the person. Like a person has to actually assign those to you. This doesn't happen with employees, because with employees, if they're doing the work that you have hired them to do, then even though, like in an abundance of caution, we had all kinds of other language, for example, with Tracklite, with some companies, they might not have them sign anything saying everything that you do is the property of XYZ company, because under the work for hire principle, with employees, that work becomes the property of the company. But with contractors, it does not. And there's some wacky contracts out there. I did some work years ago with a juice company out of Boston, and this woman had signed a website and logo contract. So it was like a marketing, branding experience. In the marketing contract, it said that she did not get the logo, and that any changes made to the logo had to be done by this person, and that the intellectual property did not transfer to her. So she paid thousands of dollars, and she really didn't own her own website, and particularly with the logo. And she only found out, of course, when she went to make changes and she decided she didn't want to use the same person, and she made some changes, and the person saw it on the website and was like, you aren't allowed to hire anyone else, you don't own that logo. And so, big issue. And you just need to read the contract. You need to look, and if somebody is going to charge you thousands or tens of thousands of dollars to do your website, you want to make sure that you own it afterwards, and you want to make sure that you've properly, we'll talk about this under infringement, but when you're getting a website done, make sure that the responsibility for getting permission to use all the pictures and all the things on your website, that either somebody else is going to work on that, or you have to make sure that then you do it properly. We'll talk about that in a minute. There's another example that happens with software all the time, is that somebody will develop software for you and then they won't want to give you the source code, because again, they want to do any changes. And there's a woman here in Phoenix who paid a lot of money to get software developed, and then she was like, you know what, I want to hire my own in-house person, so I just need this source code. And it was like, oh no, did you read the agreement? It's an extra $15,000 if you want the source code. So this happens all the time because people don't read the contracts. You get excited because you're an entrepreneur and you want to get on things, but you can save yourself a lot of headaches by reading it. The other thing is, this is a big misconception, is that people feel like, well, I paid for my website, so I must own it. It doesn't work that way. You have to go back to the contract, because you may not own the rights to it. You may own the right to use it, but you don't own the right to modify it. So it's really important with software development to make sure that you read the contract, and depending on the materiality, the size of the contract, you might want to get a lawyer to read it. So how can you avoid, paying for a lot of these things? There's a site, Creative Commons, and on Tracklite we have a resource page that has all kinds of free and paid resources, but what's on there is a whole section where you can find, the one that I use all the time is Unsplash. That's actually where this picture came from. Unsplash allows you to get photos It's just unsplash.com. You can get photos that you don't have to pay for. And I think there's an example of one. Sometimes they'll tell you that they want to have a little credit. Most of the time, the photographers don't even want credit. But generally, I try to give credit when I know. They redesign the site to make it easier to figure out. Like once you've downloaded a picture, then you actually have it in a tag who the picture was actually from. So just one last point on that. People think that they can just use these photos from anything and there'll be no repercussions. So we'll talk about that a little bit more under the don't get sued portion of the talk. So capturing and retaining innovation is hard. It's one of those things that requires discipline, and you have to put a system into your business. And you know, the big or the hard intellectual property, patents, trademarks, and copyrights, people always get all caught up in that, particularly patents. So when I say to people, do you think your business has any intellectual property? I'll always get somebody who says no, that they have none. And so then that's where I'm always like, well, I'm sure you have a name. However, quite sure most people have some sort of trade secrets. People think of them like as things like the recipe to Coca-Cola or Kentucky Fried Chicken. And those, yes, those are trade secrets. But trade secrets are also things like know-how. You know, just, it's like if I have a certain process for doing something, I have a certain way of creating whatever my product is. Or I have something like I have some unique suppliers. I have a customer list. Like, for example, for realtors, or we talked about salons, for salon people, the value is that customer list. For salespeople, it's the Rolodex. Like, that is a valuable asset. And a lot of times it's secret. So keeping trade secrets secret is a big deal. It's a big deal in the software industry because people leave and then they think they can just take stuff with them. And actually, that's in any industry. If you think about it, like wherever you worked last, you know, you probably have some job descriptions, or you probably have some other things that you might have, you know, printed or had. Technically, those belong to the company that you last worked for. They're not yours. You're not supposed to take them. So the difference between trademark and copyright, do you want me to go over that?
Trademark's a picture, right?
Trademark is the protection of a brand, or it can be a name. It doesn't have to be a picture. It can be a logo. And that is the exclusive right to use that to avoid confusion. Copyright is the idea that soon as you put something in writing, in a tangible meaning, so like this recording, I probably signed something at some point. So this recording is your recording because it's being put into a tangible medium. So soon as it's being recorded, you have copyright. Mm-hmm. So if I was recording it, then I would have copyright right away. But you can allow people to use things. Just because you have copyright doesn't mean that somebody else can't use it. It's just somebody else can't use it without permission. Unless you want to, like Unsplash, they basically say, here it all is, you can use these without permission. And so that's where people get in a lot of trouble, is they think that without the little C for copyright, that if it's not there, it's fair game. And it's not. That's not the case, but we'll talk about that under Don't Get Sued. So copyright is music, it's written, it's paintings, it's a very complicated area of law, because there's things like, okay, what if I take a picture of a painting? Or what if I take a picture of some of these icons? There's like some crazy rules around the Eiffel Tower, for example. So the Eiffel Tower is if you take pictures of it and you're trying to commercialize that and make money off of it, then the Eiffel Tower during the day is okay, because copyright lasts the life of the author plus, I think it's up to 70 years. It changes because they call it like the Disney law, because Disney obviously had a lot of money, and so the copyright used to be that it was life of the author plus, I think, 20 years, but they keep extending it to keep the protection on all of the Disney characters, because if they came out of copyright, then people could make costumes and do all these things and make money. So with Eiffel Tower, which of course is not in the United States, so it's covered by law in France, but in France they have similar, and actually around the world they have similar categories and laws. But the interesting thing is, the person who, the architect and the designer of the Eiffel Tower, has been dead long enough that that's no longer under copyright, but at night, the light show that's on there has not, the person who I think they might even still be alive, it's not out of copyright. So you can't take night photos and then try to use those to make money. Now, this is nothing to do with, us taking pictures for Instagram. That's, unless we're one of these social influencers that gets paid, but that's a whole nother topic. So having a basic understanding of patents is not enough to run your business. It's important if you are in a business where you think there's something that you need to patent. And so we have the idea of a patent that's for designs. Like, so for a pen, which usually I have a pen up here, but I don't. So with a pen, you could have a unique design, and you could get a design patent. The other type of patent that's more familiar to people is the idea of a utility patent. So let's say I invented the clicker. So it's something useful. The click, not the clicker for the thing, but the end of the pen. If I invented that, then all a patent on that does is allow me to prevent other people from putting clickers on pens without paying me a royalty or without licensing it from me. It doesn't allow me to then make pens because someone else might have a patent on the rest of it. So patents are really, it's like a whole huge area of law, but there's a lot of entrepreneurs who they just laser focus on the patent, which is okay, as long as you have, as we discussed at the beginning, you have the entity and you have everything lined up. You can go out and get your patent, but if someone infringes on your patent and you're a very small company, the only recourse is to sue them. So that's why people are always like, should I get a patent or shouldn't I get a patent? But it's good to be aware of it. So, trade secrets. Does anyone watch Breaking Bad? No? No Breaking Bad? Okay. So Breaking Bad is about a high school chemistry teacher who ends up making meth. And there's like seven...
Also, it's a feel-good story.
Yeah, 7 seasons. So no, it's no spoilers, but hence the thing from the table, not a scientist at all. But what was interesting in Breaking Bad, they started having a big fight about the recipe for this, what they call blue meth or whatever it was called. So it was an actual discussion of intellectual property, and they used the words trade secret in Breaking Bad. So even one of the coolest shows has intellectual property. But trade secrets are only of any use if they bring value to the business. So, the idea that somebody steals a customer list, well, that customer list has to not be available to the public, and it has to have value in order for there to then be a lawsuit. Now, there are a lot of lawsuits around trade secrets because of BYOD. So that's bring your own device. So if you think about it, you have all of these companies, let's just pick on Silicon Valley. You have all these companies with these incubators and accelerators, and you have everyone in there with their own computer. This is not my computer, but let's say I'm in there with my computer, and I have Dropbox on my computer, or I have now Google Drive. I'm like, oh, I'm just going to take this code, I'm just going to throw it in my personal Dropbox. So I've just stolen something, and I've got it on my own device. I can also just, if it's bring your own device, I could just download it from the company Google Drive onto my computer, and then I can quit, and then I still have access to it. So there was a huge case with Zynga, and the lawyer was quoted as saying, like, she absolutely hated Dropbox because between bring your own device and Dropbox, people were taking things. My husband works for a mining company. They don't have bring your own device, and therefore on all the devices, they can block Dropbox and they can block all these other things so people can't take things. I remember visiting Iron Mountain in Boston. They actually gave people computers that didn't have any place for a flash drive so that they couldn't take anything out. Trade secrets, that it's like multi-billions of dollars are stolen. And some of that theft comes from outside the US, but there's just, I mean, if you just Google trade secret litigation, you will see how much people actually steal. And the thing is that it's not just the big companies. There's a lot of startups where there's trade secret theft, and you know, it again, as soon as you get into this litigation or back and forth, that's when you take your eye off the ball of running your business. So, yes.
So for trade secrets for a small business, you know, and someone who's getting started up, I know have the right agreements in place is probably going to be like step one on that. But what else can you do to protect your trade secrets in knowing that, yes, you're not going to be able to buy everybody a computer that doesn't have like a flash drive? So what would be some ways that other ideas on how to protect your trade secrets?
So if you do have to bring your own device because you don't want to buy everyone laptops or something like that, you need to have a bring your own device policy. You have a policy, you have somebody sign it, that way, you know, it helps you enforce it. The sad thing about trade secrets are, though, once they're out there, particularly if it's something like where somebody steals a recipe and then, you know, publishes it, that's it. It's over. You should also, if you have specific secrets, you need to identify them. You need to, you know, mark things private and confidential. You need to call out in people's employment agreements or independent contractor agreements. You will be seeing these trade secrets, specifically our recipe or specifically our code or specifically whatever it is. And then you also talk about having policies for if you know, one of the things that often happens is you'll start discussing things with another company. Like, let's say you're going to have a partnership or something. So it's not just with your employees, it's with suppliers. And this is another area actually where people think, oh, I don't need to use non-disclosure agreements with investors or whatever. It's like, no, you don't. But when you go to talk to XYZ supplier, you should have your IP locked down. So it's also making sure that when someone leaves, that you have a process to get everything back. And that everything back isn't just your computer or whatever. It's like, let's say somebody has a copy of something or somebody has access. Make sure that you don't have former employees still having access to their email, having access, like the amount of damage that somebody could do in the 15 minutes where you think you're being nice, letting them go and close down their computer if they've told you they're leaving, or you know, if you are terminating somebody, you need to have a process. You need to make sure that you get all of that access taken out right away, because the damage, I mean, with Zynga, it didn't take long. And to put on a flash drive these days, like to put hundreds of files takes like no time at all. And you know, that can be your entire business. This is like quite a few years ago, but this person came to me and they were like, okay, so we're starting this business. Okay, so we actually started it and we have us in the East Valley. And they're like, yeah, we have 15 people working for us, but they're all family. So it's all okay. And they had no agreements. And I was just like, they claimed, no, we don't have any intellectual property. It's no problem. So I was like, okay, well, tell me a little bit more about your business. So they started explaining to me how they were sourcing like actual things like furniture and things. They were sourcing it from these places and they had, built this up. And I was like, that supplier, that chain, your process for doing all of this is your trade secret. So you're sharing it with all these people who could pick up and move across the street and open a competing business. And the woman said to me, oh, that would never happen. And I said, okay, well, it did happen to this other person that I know, travel agent, and this is like 10 years ago, travel agent with sister-in-laws, travel agent together. They get into a spat. There's no agreements, nothing. There's a company. One sister-in-law picks up, goes across the street, takes the entire client list and all the relationships and goes across the street and opens up a competing business. There's no agreements. There's no co-founder agreement because one of the things, and I didn't mention this earlier, is that in any co-founder agreement, the key provision to have is a buy-sell. Because if things go bad, or in 50% of the cases, like marriage, when things go bad, you can then just use step by step. Like, we will do this if we decide, or this person must sell to me first. Because you don't want, this actually happened to my brother years and years ago, like now 30-something years ago. He went into business with his best friend. And they had an agreement and a company and all that, but the agreement wasn't really, like it didn't step through what could happen, and it didn't prevent his partner from selling out pieces to other people. And you want that. So it all ended quite badly for them because they didn't have enough in there about what would happen to unravel things. So very, very important. So this is an example of Beverly Goodwin did the image of the Coca-Cola cap, and it said to give her credit when we took it from Unsplash. So that's what you need to do. If you think that people don't check up on this, there's programs to check up to make sure that you don't get sued. So the way you get sued is using others' work, and or you can make mistakes on social media or blogging. So the using other work, Two Broke Girls. Anyone watch Two Broke Girls? Okay. Do you remember they made cupcakes, but they made these shirts at one point with cupcakes, something to do with cupcakes and t-shirts. And what happened is another company, a t-shirt store, actually ripped off their design, but they hadn't done anything to protect it. So with copyright, you automatically have copyright as soon as you create something, but if you want to sue somebody or go after them, you have to have registered it with the United States Copyright Office. So in the story, they hadn't registered anything, and if a certain amount of time passes, then you basically have no recourse. In real life, I worked with a local artist here who filed for copyright on his designs, and they were like really cute designs, and he put them on t-shirts and everything. Great. So he filed here in the US. That means he can then license other people to use them. That means if anybody else uses them and he finds out about it, he can go after them. However, he sold a bunch of them to, I think it was France. He sold a bunch of t-shirts with these designs on them to France. And I was like, okay, but did you copyright it in France? And he was like, no, it's the United States covers. I'm like, no, the US in USPTO is only for the United States. So people have a view that if they copyright or get a patent or get a trademark, that it somehow protects them in the world. It does not. So not only is your work not sued, not only is your work not covered, you could get sued if someone else has the trademark in the other place. Funny story. Depends on how you look at it, but in Australia, when I went to visit there, and I think it was like 2008, I was looking at these restaurants and I was thinking, those look so familiar to me. And it was like Hungry Jack's. I was like, but I've never heard of that. And I went around and I saw like 5 or 6 of them over the course of the summer. Turned out they're the same color as Burger King, because it is Burger King. But they have to be Hungry Jack's because in Australia, somebody bought up the trademark for the word Burger King and tried to extort a whole bunch of money from the Burger King to come and operate. So Burger King was like, no, we're not going to pay you. We're just going to rebrand and call it Hungry Jack. So copyright, not a right to copy. There's, if you read the literature, there's a lot of talk when people go over and they get things made overseas, particularly in China, where you send over your designs or you're sending over whatever it is, and it will get copied, and then people will start using it over there. So you have to file in all these different places. As far as patents go, it's the same thing. There's a universal way of adopting that. And I was working with a startup here, and he did everything right here, but he got a call from somebody in the UK. So he's, and he actually wrote about this on our blog, so it's public. It's catalytic converter. I can never say that properly, so that was probably incorrectly said, but it's the thing in the car. So at one point there was a lot of them being stolen. So he came up with this thing called the cat lock. And so it was his invention, and he was monetizing it, and he was a startup, and he got this call from this guy in the UK about a partnership and licensing and all this stuff. So off he went to the UK, and he didn't really get any, well, he didn't for sure get any protection there, any patent or anything like that. And the guy just ripped off his design. He showed him too much when he was there. And so what happened is he came back, and then all of a sudden he started noticing that he called it something different, but he stole the exact product and design. So he couldn't do anything about it in the UK, but the guy just started trying to sell into the US. And if you have something that somebody else has copied and it starts coming in, you can actually get the US Border Patrol will enforce and not let people in. But it's a really good lesson that your value of your company has to be protected, and if you start showing people too much of whatever you've invented, whether it's patented or not, somebody's going to steal it. And even if even if this person would have been in the US, it would cost so much money to go after them. So you're much better off just trying to make sure that you get people to sign things and then don't show the wrong people too much of your stuff. Okay. So this is where people get in trouble with these photographs. And that's, as startups, most people start writing about their adventures. They might have a blog on their website. The whole idea of taking pictures for your website. There are huge fines if you do this incorrectly. So people think that you can copy anything without the symbol. So the symbol means that you have to get permission. So this is the last little story here. Social media and celebrities. This doesn't happen often, but people think that you can take pictures of anything and use it. So you can for the most part. But this is just a funny little story. So this is Catherine Heigl. And so Dwayne Reed, I'm sure this person got fired because they were the social media person for Dwayne Reed. And they said, she can't resist shopping at New York City's favorite drugstore, Dwayne Reed. So she sued them for $4 million.
Sure.
And so they settled, and she gave the money to a foundation. But you can't not only can't you just take pictures that don't have a copyright on it. The rule is, if you didn't take it, then you need to find out what the permission to use it is. And here, they should have asked her, can we use this picture or not? So it's really about reading and asking. So we've already talked about the trade secrets. So last but not least, you can't sell what you don't own. So back to the beginning, if you are an employee of another company and you're doing your startup on the side, you have to be really careful. Read your employment agreement. Do you have the right to start another company? I mentioned my husband works for a mining company. His employment agreement for a former company read, anything that he develops that has to do with the mining industry at any time, whether on a company device or at home on the weekend, is owned by them. Motorola used to be anything that you invented, even if it has nothing to do with their core business, at any time is theirs. Then you have other companies where it's like the agreement's silent on it. So it would mean that anything you invented could be yours. But it's really, really important to find out before you start working on your startup, because otherwise it would be very sad. Here at ASU, you have to be very careful. You invent something at ASU, could be owned by ASU. So it's just...
Unless you're part of the venture development program, in
Yeah.
which there's very specific rules where you own everything when you're the venture developer.
Okay, so with the venture...
But if you are an employee of ASU and you create something, that's a different ballgame. So
Exactly.
They're
So if
very
you-
clear on this.
Yeah, sometimes it's really clear. And the other thing is, if you are inventing and you are an employee of of a company, make sure that you don't do anything on your company computer. You should, even if you're allowed to do it, you shouldn't use company resources. And there's usually something in your agreement about that. And the other thing is, we've already talked about this, make sure that you are checking outside the US. Because if you don't own it, you're not going to be able to sell it. And, there's been, as people raise money or people go to sell, that's when a lot of people start looking at checklists and see whether they've done all this right. If you go to sell your company because you want to retire, you're going to have to they're going to have due diligence done on you. You can't say due diligence. That doesn't come out right. So due diligence means they're going to go back and look at all these things. So if you followed these 10 steps, you will have everything that you need for due diligence. But that's not what happens. I have friends who are attorneys who work on these mergers and acquisitions of people who are trying to retire. And generally, people have to spend tens of thousands of dollars to get this all organized at the back end, which is the good news. The bad news stories are people that don't own something because, let's say they had employees before who created something, contractors before who created something, they've left, they never assigned the rights to them. So you have to own it. So it gets back to the big takeaway is to read. Just read everything and hire somebody to read things. And so just to end, I think this is, there's just a couple quick things. People think, I think I've mentioned this several times, that IP is just for a tech startup, but actually any business has IP, and you all will have trade secrets. And for startups, this number is actually 90% of your value is in intangible assets. Because as you start up, you're likely going to rent. You're not your employees or your contractors are bringing their own computers, you don't really have any hard assets. You might have paid some money for your website. So your value, as you're raising money and putting valuations of millions of dollars on your company, it's all intangible because you don't have hard assets. And sadly, ignorance is not a defense. So if you say, I didn't know, I'm so sorry I used that picture, Google people don't find me, they will just laugh. And so then, any questions?
So
Any more questions?
So real quick, sharing and using content on social media. So you talked about social media, and I think, Katherine Hagel's kind of the obvious, someone used
Yeah.
her, which she's litigious to begin with, so it's just a silly choice. But someone's writing a blog, right? Resharing blogs and things like that. I know people get really touchy about that, they get concerned about it, but then you have small businesses who just don't do anything out of fear of sharing the wrong thing or taking people's property. So what's that balance when it comes to social media when you're sharing other people's ideas?
So if you look on different websites, they will usually have a policy for, sort of reprinting or linking. And so sometimes they'll say, it's okay. Other times they will say, you can't use this without permission. One of the things is that if you have a blog and somebody else has posted that blog, you can post a link to it and say, hey, go see this. But if you just copy what they've written, you can't do that. So,
but if they post it on Facebook and I just hit share,
then Facebook is that's a whole different story. If you just hit share on Facebook with something that somebody has posted there, then it will show you the attribution. So it's the old adage of give credit where credit is due. So if you're going to give the proper credit, then people usually are fine with sharing that. Or, if you look at memes and all those things, that is something where if somebody wants to protect it, you'll see at the bottom, they will say, created by or whatever. And just because they don't say copyright doesn't mean that they're not trying to protect it. Mm-hmm. The bigger problem isn't Facebook and friends posting and things. It's anything that's on a company's website, you should then basically ask if you're going to use a picture or a video or something like that. But something fun on Facebook or Instagram, as long as it's linking back to the original. And the key would be, it's like plagiarism, right? You don't want to pass it off as your own work.
And so the last question that I'll have is, you've given lots of risks, right?
Right.
There could be people that are listening that are hearing nothing but cha-ching, 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 cha-ching. How do you balance, right, being protected and finding those right pieces and getting good advice with the perception of high-priced lawyers and what that looks like? What are some strategies that you'd recommend?
So a lot of this you can do yourself. But I don't advise that you file your own patents.
Yeah.
People can do it, unless you're very, very technical. But there's a lot of things that I've been saying that you can go and you can find free resources to learn about it. TrackLight itself has we have a free business risk assessment, and it links to a whole bunch of resources. Some of them are paid, but a lot of them are free. And for the attorney side, you need a really good set of employee agreements and independent contractor agreements. If you're part of ASU, you're part of the incubators, you're anywhere in any major city in the US, you can usually find lawyers who will give you a package of that for a flat rate. It's not necessarily super expensive. And then you have options like LegalZoom has a small business package. Legal Shield has a small business package that, these are under $100 a month, and you can get letters written, you can get access to employee agreements. Rocket Lawyer, I always get it confused with Rocket Matter, which is a totally different thing. Rocket Lawyer is another place where you can get very inexpensive and sometimes free. Like we leased our house here. I went on and got a free lease that applied in Arizona because I don't practice law here. I got a free lease off of Rocket Lawyer. So there's lots of these solutions. We have them listed on Tracklight, and you can also talk to your fellow entrepreneurs. People share stuff. I'm not going to necessarily say this is a great idea because sometimes the circumstances are different between companies. You should definitely not borrow something from a different state because state by state is employment law. But anything to do with trademarks, patents, all of that, that's US wide. So you can do that. Also, I think, do they still have mentoring? Yeah, so there's mentoring, and you can find lots of creative ways. The trick is to not just go, oh, it's too boring, it's too much work, because it will bite you. We have lots of stories on our blog of people who, are like, there was one infamous guy who was a fellow client at CEI, and he was like, I don't have time for this. I don't need to do this. I don't need to do this. And he got in front of his investors, and they're like, wait, you have no strategy for your patents. You have no strategy. You haven't even protected your name. And then he found out he went to try to protect his name, and he had a problem. He had to rebrand and redo everything he had done. So that is not the way to do it, and it doesn't cost as much money if you start from the beginning.
There you go. Well, round of applause for Mary, and I'll wrap it up there. Thank you, Mary. And so on that note as well, I didn't really give a opening statement.
Oh, that's okay.
So for those who are videotaping, thank you to Mary. She is one of our amazing speakers that is part of the Training and Development Network with Entrepreneurship and Innovation. So our team, and we are part of Peoria Forward. So Peoria Forward is a program that is a strategic partnership between the city of Peoria and Arizona State University's Entrepreneurship and Innovation team. We build resources like Mary to come out to Peoria. We also have some of the resources that she mentioned, mentors, access to additional training, some of these templates, incubators are all accessible for Peoria residents and Peoria business owners through Peoria Forward. So tonight's training is just one of several series of programs that are available, plus all the resources that are available. entrepreneurship.asu.edu/Peoria-forward. So make sure to check it out online. Thank you, Mary, for coming out and sharing all the information
Thank you so
tonight.
much.
We appreciate everybody coming out tonight.